Good afternoon, everyone, and welcome to DataMatters. This is the second lockdown in the UK, and of course, the sun has decided to start shining on us again, which at least is quite nice. I'm Vicky Gilwar. I'm a partner at Privacy Culture, and I'm really delighted to be joined today by Kim Rose. Hi, Kim.
Good afternoon, Vicky. How are you?
Very well, thank you. And you?
Yeah, very well, thank you. Pleased to be with you.
Excellent. Thank you so much for coming on the show. And also Neil Smith. Hi to Neil.
Hi, Vicky. Hope you're well.
Very well, thank you. Thanks so much again for coming on the show. So our guests today both are extremely experienced in the world of data protection and information governance, and they're going to help us navigate what I think is often such a neglected topic of privacy in the workplace. So I'm really looking forward to unpacking this with you today. So just to set the scene a little bit, I think it's fair to say that employees are generally unaware of their employees' rights when it comes to privacy or any other issues in the workplace. And unfortunately, this is an area where ignorance is definitely not bliss and could potentially land you in a lot of trouble. You know, as an employee, we all have rights, and by law, to our own privacy at work, within limitations, of course. According to the law that stands today, there are three main privacy rights that employees have, which both an employee and an employer must abide by. These are use of telephone and email, surveillance, and the right to protect personal data, the latter reflecting both parties. And in the employment setting, there are unfortunately a number of areas in which an employee's practices might ultimately violate an employee's privacy rights. So let's go over just some questions. So initially, the protection of personal data, of course, is very important. Even from the very beginning, when someone applies for a job, an employer can gain knowledge of personal data, including name, address, and contact details. By law, they're not allowed to misuse or broadcast any of this information. And if that person goes on to become a member of staff, an employer will probably find out their next of kin, ethnic origin, sexuality, religious beliefs, and more. And this must all be kept strictly confidential. If an employer is thought to have misused an employee's personal data, they're in breach of the law, and this can lead to a court case. So I'm going to go over to Kim as a starting point. Can you please outline the rules and specific employment laws that need to be adhered to here?
Sure. For me, I think the key ones, Vicky, are the Employment Rights Act 96, the Equality Act, clearly Data Protection Act 2018 and GDPR. Then we've got the Right to Work Act for non-UK nationals, and the fundamental one for me that the recent Morrison's employee case involved is the Computer Misuse Act 1980. Often one that's overlooked, but actually you see often on PCs when you start these days, there's a banner that says, please be aware of the Computer Misuse Act.
Thank you so much, Kim, for unpacking that. Yeah, I think that, you know, those often get forgotten, don't they? So an employer may have a legitimate business interest in videotaping its employees. However, to avoid running foul of an employee's privacy rights, employees should actually videotape in open or public areas in which there is a diminished or no expectation of privacy, for example, on the shop floor. And the employer should give its employees notice that they're being videotaped as well. In fact, the case of Germany as well, H&M is an example where surveillance is taking a length of. So what scenarios might be permitted, and what steps to take to ensure we're on the right side of the law? Neil, have you got a comment on that?
Yeah, I mean, I think this is it's quite a tricky area in some respects. I mean, in my experience, you generally use surveillance in three areas, and that's for your safety of your staff or your visitors to your business or to your organisation, for crime prevention, and for things like identifying malpractice potentially. So you could also have CCTV or surveillance, for example, which you might use for security, and that might be for general security or internal security. So you tend to get things which are secure areas like your server areas, which you might want to protect access to, and you might want to control who's going in and out of those particular areas. So surveillance can be quite a useful tool and can be quite an effective method of identifying weaknesses in your business, and also for protecting your data holistically as well. Now, I know you mentioned the H&M case, which is one of those recent ones, and that was quite interesting in itself, I think, because they were effectively gathering data and building profiles about their staff, which they had no lawful basis to do. It wasn't for a legitimate interest or a greater good, and you have to balance that between the aim of an organisation or a business and the rights of individuals themselves. So I think you have to be careful, I suppose, if you are an employer or an organisation using surveillance, and you've got to contrast between the rights of an individual and their freedoms and what you actually want to achieve. So you can contrast the H&M case with other cases that have been around in this area, and there was one I was reading the other day, dates back to 2013, so it's pre-GDPR, but it gives an idea of where surveillance might be useful, and that was where there was an employee who worked for a county council, and he was skipping out of work to play squash, but he was billing for the time he was working. So the county council put him on the surveillance and tracked him for a little bit, and ultimately dismissed. He brought a claim for dismissal, and went through the tribunal process, and it was ultimately held that the council was justified in putting him on surveillance because he was committing fraud effectively. So it was a fair dismissal. But in terms of the context of this conversation, there's two key takeaways from that case. And the first one is that there cannot be a reasonable expectation to privacy when concerns fraud or more severe criminal activity potentially. But it also outline the fact as well that you cannot expect privacy when you're at work 100%. So there may be CCTV in your office. That's aware about that. It's there for a reason. You don't necessarily expect that you're going to be completely immune from any kind of surveillance, I suppose. So I think ultimately in this area you have to consider the legitimate interests of both the organisation and of the employee themselves. And if you are going to use things like surveillance, you need to weigh up whether you're going to use covert or overt surveillance, how you're going to use it. Is it proportionate to what you want to achieve? So there is a bit of a balance act there to make sure you're complying not only DBA, GDPR, but also your Article 8 rights of the Human Rights Act. Fortunately for us, again, there is case law which can help us, and there was a case back in 2017 called, I'm trying to get the name right, Barbalescu, I think, and was concerned with CCTV in particular. So that's a principles that can help us understand whether or not we are acting in accordance with the athlete rights. I'll put them through without time. So the first one was making sure that you notify individuals that CCTV may be in use. You don't necessarily need to point the location of every single camera, but you might have a notice on your external office door that says we use CCTV. People need to be made aware of the extent of their use, so that might be in like an employee handbook, for example, or some kind of notice that you give to your staff when they join. You might want to set out the degree of intrusion in there, why you're doing it, how you intend to use that type of information you obtain, and set out your lawful basis, and set out the consequences of it. So, for example, how it be used or could it be used in police investigations or disciplinary investigations and whatnot. and then outline the safeguards. So by that, I would think things like how long are you going to keep it for, how you can access it through a desal process, that type of thing. And if you satisfy those 6 criteria from the Valvalescu case, then generally there'll be no breach for now to play. But if you can't satisfy that, that's when you're going to come unstuck. So it is weighing up your aims and your objectives against the rights and freedoms of those individuals.
Some of the key call-outs that I heard from that were, proportionality. Really balance what it is that you're actually doing. If you have that in place, if you're operating in balance, if you've weighed up the risk in terms of what you are doing around surveillance, then you should be in a good place. So just sort of picking up on one of the points you made there, Neil, and maybe Kim can step in with some examples as well. So, an employee has the right to know what their personal details are being used for, if any checks have been carried out on them, for example, CRB checks, the results of any checks, and exactly what the employer knows about them. I understand that they have the right to refuse any tests or checks that have no business purpose. And so what happens if an employer doesn't abide by this? Can staff actually go to the police?
That's a great question, Vicky. I'm not sure about whether staff can access the police. It's not something that I've been directly involved in, but of course, anything that is an illegal act, the police are duty bound to investigate. I think there are some sort of mitigations that you can put in place. Neil covered quite a lot of ground with his explanation. And so for me, it's really about the fair privacy notice or fair processing notice. And that typically you'd have on a staff intranet rather than on the public facing website because of the diversity of information. The Article 8 European Court of Human Rights Act is clearly one that a lot of people miss when they're conducting these types of things. Subject access is not the only issue. There are some freedom of information request implications in HR data as well. And there's a lot of data sharing activity with some of the public organizations, especially from the public sector. So I've seen a couple of instances also where human resource departments are using increasing video interviews and video recordings and audio recordings of disciplinary meetings. And so those have implications because often data subjects and or employees may want copies of that information. So subject access request, yes, you can request everything that's about you in a personal or personnel file, electronic or paper. And that's quite often very difficult to do. And you have to take care of subject access requests to redact any third parties who haven't given explicit consent. So it is quite a minefield to walk through. And yeah, I think that those are the fundamental parts that I've seen. The only other comment that I would add is where video surveillance is used for frontline policing, frontline ambulance, frontline fire, where there's a risk to life. And most of these things are actually fairly well covered if you do a comprehensive DPIA from the surveillance camera guys, the commissioner, same as the ICO. It's a very specific and unique DPIA template, but really does make you think when you go through them. And I've done a few recently, so it's quite an interesting way to view things. Definitely.
Thanks so much for that, Kim. So let's move on now to the use of telephone and email. So an employer needs to follow the guidelines outlined in the Human Rights Act, one that we mentioned earlier, and respect the private life of an employee. So does this mean that throughout the working day, employees are allowed by law to use telephone and email for private purposes, not only during break times, but throughout the day?
Yeah, I think for me that would be something that it's really driven by the trust that you engender in your staff, and driven by policy as well. So most policies will allow the use of telephone and email during the day. That should be throughout the day, because you may have an emergency situation that you can't otherwise counter. And so policies have to allow a certain amount of flexibility. But it's I think really the intent is trying to stop people sitting there on their mobile phones, just Facebook Messenger and all other flavors, of course. So yeah, I think employees do have rights there, and it's really, especially with COVID, I think the changes now are lots of people are working from home, and it's a different way of managing staff, and that's going to be a really difficult transition for the HR community.
Yes, absolutely. That's a really, really good call out. And just over to you, Neil. Did you have any builds on that?
I think I'd echo what Kim has said, really. I think it all depends on the nature of your organisation and your workplace. If you're working in a particularly regulated area or high-risk area where you're dealing with confidential information, whether that be pure personal data or sensitive commercial data, you're probably less likely to have access to your mobile phone with a camera or a video to be allowed at your desk. For obvious reasons, but as has been alluded to, we're in a current unique situation where you may need to be on call, whether you've got a family commitment or other reasons why you may need to have access to a device during the day when you wouldn't usually. So again, I think it's all about what's proportionate in the situation and what safeguards would you have in place. So it may be that you can use your phone, but you have to use it away from your desk in the break room. I think if you had a blanket ban, that might not be reasonable in the current situation. So I think it's just weighing up the pros and the cons.
Absolutely, yeah. As you say, back to proportionality. It's really, balance is definitely a theme that's through here already, isn't it? And the employee must protect any sensitive data about the company they work for and not pass anything on to a third party. Breach can lead to disciplinary action, potentially even dismissal. Kim, what have you seen happen in this space, and what can be done to avoid it?
I think, so my observations in this space, I've seen people leaving computers open, switched on with sensitive and confidential information on there. I have been involved in a fairly significant, or investigating a fairly significant data breach where actually a supply chain company had gone out of business. They had the records of a significant number of vulnerable children, which had been deposited in a rented facility. That rental agreement came to an end because the company was out of business. The data was out in the wild. Now, as the data controller the company's logo was on that information though, so therefore it became our responsibility to resolve it. So actually managing your supply chain and understanding that you've got those contracts in place, as GDPR dictates anyway, but actually regular audits of your supply chain, so following the NCSC guidelines. Other than that, planes, trains, automobiles. Traveling to London one day, saw a cybersecurity company executive with his MacBook open on the train, decided to go to the bathroom, left that open with an iPhone next to it doing the data connection. I'm thinking, okay, you couldn't make it up.
No, not at all. Thank you, Kim. Neil, any examples to share from you?
Very similar, I suppose. I mean, in my career in various organisations, I've seen things such as people sending work to their Gmail account or their Hotmail account because they want to work at home, but they don't have access to a work device. So not always done securely. It's not very well encrypted in the main when it comes to Hotmail and Gmail and things like that. So that's one thing which has come up time and again for me. Other examples I've seen, people leaving laptops on trains or in taxis, dropping things in car parks, confidential stuff that relates to the business, relates to their customers, their data subjects who they manage, things like that. And it's all down to carelessness, I suppose, if I'm honest, just taking your eye off the ball for 1 minute and you've left it on the train and memory stick's gone, and then you have to ring IT and they have to do a fair bit, and it's just a headache for everyone.
Absolutely, yeah. So I suppose that, that's the one positive thing. We're all doing a little less travelling at the moment, so there's less chance of these things happening on planes and trains, right? So I think let's start looking at some of the procedures. I know you both kind of touched on some of the good practice steps that people can put in place, but I think it's definitely worth covering and unpacking these a bit more. So protecting the privacy of an employee, of course, is incredibly important when you are an employer. We must think about legal factors and consider those, and if you intend to conduct surveillance and monitor employees, if there is just cause for you to do so and you've made sure that employees are fully informed, most employees, I think, won't strongly object to the idea. But how do we go about this? How do we put this practice in place? Neil, did you want to start unpacking that for us?
Sure. I mean, for me, I think it can be achieved through three key things, really, or three key activities. First of all, it's your fair processing notice or your transparency statement to individuals, whether that be your staff, your visitors, whoever, to say that you are going to be using surveillance such as CCTV, or you may be monitoring their use of email or social media or whatever it might be. That's quite critical for me, because I think you need to be transparent, you need to be open about it, and then there's no chance of them saying, well, I didn't know that you were recording me, filming me, going to check my email and all that type of good stuff. So the fair processing notice is obviously the number one starting point, in my view. Secondly, your ROPA, so make sure any activities relating to surveillance, as much as you can at least, documented in there, because that might involve sharing with third parties. So that could be the police or law enforcement, it might be regulators, it could be other third parties involved in your business or your organisation. So ensuring that it's fully documented in there and you've got your data flows. That's quite important as well if you're doing things involving international transfers of data. So if you're transferring CCTV footage or recordings or whatever it might be outside of the European Economic Area or to America, especially in light of Schrems, that's quite important. And then the third one would be through your DPIA or your legitimate interest assessment process. So making sure you've set out exactly what you're doing, why you are doing it, what your aims and ambitions are, and then you can draw from that privacy risks that you foresee from that, what you're going to do to mitigate those risks. So I think if you have those three things in the back of your mind when you're thinking about surveillance and monitoring of staff, employees, visitors, whoever, then you can't go far wrong.
Excellent, thanks Neil. So just to reiterate again, so that's having your fair processing notice in place, that's having your ROPA up to date, and it's completion of your DPIA. So just over to you now, Kim. So those are all great things, but how about getting employees fully up to speed and fully informed? What's the best way to make sure that everybody understands where to find this information?
Okay, so I would say that training is always, whether it's online training, face-to-face training, which is clearly difficult given the current situation, regular bulletins on staff intranets or information that flows out through your ICT systems. In our organisation, we have a number of sort of splash screens and daily things that come up. Having a really good ICT service provider really does help as well, making sure all of your systems are in order and secured, regular role-based access checks, things like that. And actually tools and systems that helps frontline staff. So email systems where they may integrate with Outlook and advise you if you're sending to a recipient you've never sent to before, especially in the context of patient data, confidential data, etc. Because frontline staff typically in most organizations are not ICT experts, they're not information experts. So we need to sort of understand the target audience that we're talking to, and you know, bring it to life for those people.
Excellent, Kim. Yeah, I really like that you mentioned that the whole holistic approach there, really, of making sure, as you say, that there's simplification, the tools and processes that are in place are easy to use, easy to navigate, and you are condensing your message or targeting your message at different audiences in the way that they understand. So as you say, you've got people that may not have access to the intranet, so they may only find out this information as part of a weekly stand-up or a conversation with their manager, and others, the intranet email is more of a daily interaction for them. So I think that's a great point. So there are a few more questions that have come in here. So an employer's search of an employee's person or private belongings is perhaps the most intrusive form of employer inquiry. However, a physical search may be warranted and lawful under certain circumstances. Kim, again, where and what could justify such a search, and should they be following some guidelines in order to do this?
I think so. Let me try and address the first point. Where it's deemed appropriate is if an employee is suspected of carrying drugs, alcohol, illegal weapons, and really if you have some evidence to back that up, so you're not just going on a fishing expedition. And I think in those instances, really, that should be, again, good policies and processes, good communication with staff to say, we are doing these regular checks. And I have seen that implemented quite well in a couple of organizations. And it depends on the type of organization that you work in. So if you're a military contractor, that's clearly a much higher, ongoing risk. So, when you go through the airport scanners, for example, same thing when you go to a government building. So I think it's, I'll use one of Neil's comments, proportionate and appropriate.
Great, thank you. Yeah, that was really good to sort of articulate those examples and understand those examples. I wouldn't have thought about some of those. Neil, do you have any builds on that before we move into the next question?
I mean, like Kim has said, it's likely, in my experience, be limited to exceptional circumstances where you would search an individual. So if they are suspected of a criminal offence, for example, or like you mentioned, drugs or carrying some things which they shouldn't, so something prohibited. I think you've got to be very careful here because you need to do it based on evidence, not just conjecture or just an unsubstantiated claim. But you've also got to be mindful of the fact that you could be assaulting somebody if you just randomly search them. So there's other implications outside of the employment and the data protection realm to consider. So you need to be thinking about, do I need to search in the presence of like a police officer, for example, maybe, or a person of the same sex or same gender as the person who's being searched. I think you've also got to bear in mind, does it say anywhere in your contract of employment you may be subject to searches as well, because that will aid in the transparency of things. So you can then say, well, I was made aware when I signed my contract of employment I may be subject to random testing or random searching or whatever it might be. So I'm just going to repeat what I said before. It's all about the proportionality and the reasonableness, and if you've got a just cause, then you should be able to document why you're doing that and the outcome you want to achieve. So it's just got to be more what is reasonable in the circumstances.
I mean, I was just thinking, as both of you have been speaking, this is an area where there are, as you say, there are so many different regulations to consider. There are contractual obligations to consider. Your contracts with employment as well as contracts with third parties and others. So pragmatism here is so key, isn't it? And because that proportionality piece, the balance, and being fair. And I want you to sort of dig a little bit more into the communications area, because it really is a piece where we need to get the education right in this area. So have either of you focused on a particular campaign specifically for the workplace? So privacy in the workplace for employees to understand their responsibilities. I'll be really interested. I see, Kim, you're nodding there. I'd be really interested to understand what a campaign delivery would look like, because there are so many areas to target.
Yeah, so the way that we try to do it, and I've done this in 2 or 3 organisations working hand in hand with the ICT providers, is things like phishing campaigns. So the 2 most recent ones that we undertook were targeted about COVID-19, because it's of the moment. And prior to that, there was an HMRC letter doing the rounds. So we thought, okay, what we'll do is we'll try this with everyone that's working from home on a VPN connection. So it was a very specific subset of users, some of which who hadn't been working at home before and hadn't had that VPN connection. So obviously it was an internal thing. And off the back of that, we went through our internal communications with the comms team. We didn't signpost it in the first instance, it just went out. And we used that in our committee follow-ups to say, okay, well, these were the number of people that opened, these were the number of people that clicked, and these were the number of people that would have been phished. And actually rolling that into some of our background systems to understand, well, where are the risks? Where are the issues? And so when we did the second campaign for COVID, there were a lot more people working at home. Probably, I think in the first instance, we had something like about 250, second instance was about 1,500. So, significant difference. But actually the figures were very much the same. And I think it was because we'd already done the first campaign.
Right, okay, that's great. So people had been made aware and were, looking out for this kind of stuff when it came out next time. Excellent. And Neil, do you have any examples of campaigns that you've run in a similar?
I mean, we have done where I've worked before, previous employment, we've done similar exercises where we've sent out kind of dummy phishing emails to all our staff, and then it's got like a link, and we just then monitor how many people have clicked the link, how many people have followed the process to refer it to our information security departments, and then from that further comms follow to say, this was a test, this is what it means for you as an individual, this is what it means for us as a business, and to educate people on what they should be doing with things like that. So very much along the lines of what Kim's done as well. I've also ran or helped run just general awareness campaigns in previous organisations. So when GDPR was about to go live, if you like, we had a big campaign on the whole framework of GDPR, what it is, what it means for the business, what it means for individuals, how it's going to change the data protection landscape from what it was under the 98 Act, and just to give people an awareness. So we weren't expecting everybody to be experts on data protection, because that's what we're here for, but it's to give them an understanding of what it means for them and try and make it relatable to individuals, because I think personally that's where a lot of people come unstuck, because they don't understand how it relates to them and they can't see the bigger picture necessarily. So it's all about breaking it down almost to bite-sized chunks for people who are not SMEs and not data protection professionals, so they can understand, this is what I need to do, this is how I do it, this is how I report a data breach or a phishing email or whatever it might be, and how I can make the business more accountable and compliant.
Excellent, thanks Neil. Unfortunately, we've run out of time, as ever. We get into the discussion, but some fantastic points were made there, particularly I think around, how do we land this, how do we communicate it, and making sure that your processes are as easy to use for people as possible, and that they know where to go. So, to Neil's point, who do you actually go to find out more? Neil mentioned we don't expect people to be SMEs, but we do need them to know who to come to if they do need help, and just some of the basics there, and just to keep that, pragmatism, proportionality in mind, if you are somebody that has to consider taking any action in this space. So thank you so much to both of you, to Kim and to Neil, for being on the show this afternoon, and for giving us your insights. So next week we will be joined by Steve Wright again, and we have a panel, so really exciting, a slightly different approach, and we'll be looking at the role of the CISO and the DPO, so looking forward to this time next week when we do that. So for now it's goodbye from me and goodbye from Kim. Oh, I think Kim's on mute.
Very much for inviting me. It's been very enjoyable.
Oh, pleasure. Thank you so much for coming on the show and giving up your time, Kim. And goodbye to Neil as well.
Yeah, thank you for having me. It's been a pleasure.
Thank you so much, both of you. Thanks to everybody for joining, and we'll see you next week, same time, 2 p.m. Have a great weekend.